Shareholders agreement is an agreement between shareholders. It's not too hard. The difference between the Articles of Association and the shareholders agreement is it's only between the shareholders. Before the articles you saw are for all the bodies. It's the constitution. The shareholders agreement is something that you can secretly agree on, keeping in mind that the Finanzamt, the tax authority, is let into the secret if you notarize it, because you should notarize it and have like the highest form that is possible in the private law, because it relates highly to the Articles of Association. So if you want to save money, put all the clauses that we put in the shareholders agreement into the Articles of Association, but they're going to be public. And sometimes you don't want the sensitive data to be public. So it's up to you. You know, you have to pay for your privacy, so to speak. What do you put in the shareholders agreement? All critical clauses, and we have included them all in the templates. Again, you see it's red meaning, oh, it's important. So if you mess that up, this would be one of the cases where you will regret it later on, really big time. Because as shareholders, you want to stay together. You know, you don't want anyone to come into the company or leave the company not working properly, and so you want to kind of have a hold on that, or you don't want your fellow shareholders, fellow co-founders to screw you up and work for a competitor or something. This is why you have non-competition clauses. This is why you have vesting. And when you sell the company, you want to sell it together. So this is why there are drag-along rights, tag-along rights. So the reason you should, in my opinion, put it up from the very beginning is you cannot do it afterwards if not everybody agrees. So if you agree from the, you have to think with the end in mind, you agree from the start, then you don't have to think about it later, and you don't have to, let's say, buy someone off. Let's talk a lot about, in detail, more about vesting. Vesting is the most important clause, I would say, because it makes sure that all the founders work together in the company and none is just sitting back and doing nothing. What does it mean? It means that you have to return your shares if you stop working for the company within a certain period of time. That is the vesting period. Typically, it's maybe 4 years, it's 3 years, 5 years, but let's say 4. And what does it mean, stopping to work? Stop working means you either resign. Let's say you are the managing director and you say, I quit, screw you, you leave, or the company fires you. And you want to make sure that the company cannot just fire you for any reason, because in the scenario with 3 founders, you have 67% against you, and they could fire you right away if they wanted to, unless you use our templates, of course. And in the templates, we only allowed firing for good cause. So this is something that would be allowed if you don't put it in a contract. Also, if you just sit back and refuse to work, that's also constitute reason for vesting. Stop working. There is one thing, and we'll see it in the graph. During the first 12 months, which would be the cliff period, you would have to return all of your shares if you stop working within that period. That's optional, but it's typically in the contracts, because if someone leaves that early, he didn't really contribute anything, and you don't want to have him as a shareholder anymore. But after a year or so, people say, okay, you stay shareholder. He doesn't have any voting rights anymore. He just, gets the profits that he earned so far, but he will get to keep at least 25% of the shares. And after the vesting period, when you leave, you're free to go. You just keep your shares. So that's the deal.